Last 5 seconds. Ready? Start. At the outset, counsel for the appellant submitted that since the appellant is in jail from 24th February 2015 and he has completed more than 7 years, including remission, therefore he may be sentenced to the period already undergone by him. The submission made by the counsel for the appellant cannot be considered unless and until the case is considered on merits. However, the counsel for the appellant did not argue on merits and stick to his submission that the appellant may be punished with the period already undergone by him. In the light of judgment passed by the Supreme Court in the case of Nagpal Traders versus Devinder Singh reported in 2017 11 SCC 431, the question of sentence cannot be decided unless and until the appeal is decided on merits. Accordingly, this court is left with no other option but to consider the merits of the case on its own after going through the record. According to the prosecution case, on 23rd February 2015 at about 6 p.m., the prosecutrix PW1 had gone with her kettles along with her younger sister PW2 to Kumhar Gadha well for providing water to her kettles. At that time, the appellant came there and gave ₹40 to the younger sister of the prosecutrix and instructed that she should equally share with the prosecutrix. The appellant also suggested the younger sister of prosecutrix that she should stand there, and thereafter he caught hold the prosecutrix from behind and gagged her mouth. He dragged her to a nearby place where the appellant committed rape on the prosecutrix and also extended a threat that she should not narrate the incident in her house, otherwise she would be killed. Thereafter, the prosecutrix came back and informed the incident to her parents. Since it was already late in the night, therefore the FIR was lodged. On the next day, the police prepared the spot map. The prosecutrix was sent for medical examination. The vaginal slide and undergarments of the prosecutrix as well as the undergarments, pubic hairs and slide of the appellant were sent for FSL report. The school record of the prosecutrix was seized. The appellant was arrested and he was got medically examined, and after completing investigation, police filed the charge sheet for offence under sections 376(1), 506 part 2 of IPC and under section 3/34 of the POCSO Act 2012. The trial court, by order dated 17th March 2015, framed the charges under sections 376(1), 506 part 2 of IPC and also under section 4 of the POCSO Act 2012. The appellant abjured his guilt and pleaded not guilty. The prosecution, in order to prove its case, examined prosecutrix PW1, her younger sister PW2, the father of the prosecutrix PW3, Dr. Sunil Jain PW4, the mother of the prosecutrix PW5, Dr. Anjana Jain PW6, Ramesh Chandra Sharma PW7, Kalu Ram Parihar PW8, Srimati Anjana Khare PW9 and Ravindra Singh Sikarwar PW10. The appellant examined Santosh Jatav DW1 and Dr. ML Agarwal DW2 in his defense. The trial court, after considering the ocular as well documentary evidence, held that the age of the prosecutrix was 14 years and the prosecution has succeeded in establishing that the prosecutrix was raped by the appellant and accordingly held the appellant is guilty for offence under section 376(1) of IPC and under section 4 of the POCSO Act, but acquitted the appellant for offence under section 506 part 2 of IPC. Since the appellant was found guilty for offence under section 376(1) of IPC and under section 4 of the POCSO Act, therefore, in the light of section 42 of POCSO Act, no separate sentence was awarded for offence under section 376(1) of IPC, and the appellant was sentenced for a rigorous imprisonment of 10 years and a fine of ₹5,000 with default imprisonment of 3 months for offence under section 4 of the POCSO Act 2012. The prosecutrix PW1 had claimed that she is the student of class 8 and she is aged about 14 years and her date of birth is 22nd April 2001. It was further claimed that she resides with her parents. About 1.5 months prior to the date of her examination, she along with her younger sister had gone to a well and was giving fodder, and the appellant came there and gave ₹40 to her younger sister and suggested that both the sisters should share ₹20 each and instructed her younger sister to stand there. Thereafter he caught hold of her and took her to a nearby place where he committed rape on her. He also extended a threat that in case if the incident is narrated to anybody, then he would kill her. Thereafter, the prosecutrix came back to her house and informed the incident to her parents, and since it was night and they were afraid, therefore they went to the police station on the next day and lodged the FIR Exhibit P1. Therefore, she was sent for medical examination. In cross-examination, it was accepted that the land of the prosecutrix as well as the appellant is joint and the well is also joint. She denied that the father of the prosecutrix had not returned the money of the father of the appellant. She further stated that the incident took place at a place which is about half kilometer away from her house. She further claimed that although she was resisting but he did not run away. She further denied that the false report was lodged on account of property dispute. Stop.